Since we have about a minute before we're slated to start, could I get confirmation in the hearings room that you can see and hear me?
Yes, we can see and hear you.
Great, thank you.
We all set on our end, Stephen? Are we all set on our end? All right, I can hand it off to you, Hearings Officer Brooks. Looks like we're all set here in the hearing room.
Great, thank you. So let's go on the record. The time is 1 p.m. This is the hearing for Deschutes County file numbers 247, 24392 PA and 247, 24393 ZC, which is a request for a plan amendment and zone change on the subject properties. My name is Tommy Brooks, and I am the hearings officer in this matter. Before we turn to the specifics of the hearing, or at least to the substance of the hearing, I'd like to turn things over to Ms. Mardell to describe how the participation process will work.
Excellent. Thank you, Hearings Officer Brooks. Good afternoon. For the record, my name is Nicole Mardell. I'm a senior planner with the Deschutes County Planning Division. And the item before the hearings officer today is a comprehensive plan amendment to change the designation of the property from agricultural and surface mining to rural residential exception area, and a corresponding zone change to rezone the property from exclusive farm use and surface mining to rural residential. Today's hearing will proceed as follows. First, staff will provide a brief, first staff will explain the hearing format and how to testify at today's hearing, followed by a brief presentation on the application. The county has established time limits for testimony as follows. The applicant will have 30 minutes to present, followed by public agencies if in attendance, and they'll have 10 minutes to present their testimony and evidence. The general public will then have 3 minutes per party to present their testimony and evidence, and the applicant will have a rebuttal period of about 10 minutes following that general public testimony. The hearings officer can modify or eliminate these time limits at any time during the hearing. The hearing will be conducted as follows. The applicant will present first, followed by agencies. Next, persons in support will testify, then those in opposition, and finally, anyone neutral to the applicant's request will testify last. Afterward, the applicant will then be afforded that opportunity to present their rebuttal testimony. And finally, staff can make any closing comments as requested by the hearings officer. This is a hybrid hearing with both in-person and remote participation options. Before starting your testimony, please provide your first and last name as well as your mailing address. For our in-person participants, if you wish to testify, please add your name to the sign-up sheet here at the table at the front of the room. I will use this list to call participants for their testimony. After your name is called, please come up to one of the tables at the front of the room before beginning your testimony. For our remote participants, if you want to testify, you must be logged into Zoom or have called in using the Zoom dial-in option. When Hearings Officer Brooks asks if anyone attending remotely would like to testify, you will need to use the raise hand feature to notify staff. To do this, you'll need to press the raise hand button on your computer or smart device, or if you called in, dial *9. And for those using Zoom, the raise hand button may also be under your reactions tab. In addition to oral testimony, if anyone has written testimony that you would like to submit, please hand that to me. If you're in person, you can submit that to me after you provide your testimony. And if you're participating remotely, you can submit your written testimony to me via email at the address here, nicole.mardell@deschutes.org. Hearings Officer Brooks and staff are responsible for conducting an orderly hearing. Any testimony or behavior which is inappropriate will be addressed and may result in that member of the public being removed from the hearing. At this time, I would like to ask if there are any objections to the format of this hearing. If you're attending remotely and have an objection, please use the raise hand function. Seeing none, I will turn it over to Hearings Officer Brooks. Oh, and it appears you're muted still. Thank you.
Sorry about that. Thank you. And as Ms. Mardell just described, we're going to follow the normal hearing procedures that are set forth in the county's code. I will provide sufficient opportunity for everyone to participate at the appropriate time. This application is being considered through a quasi-judicial process. I will consider only the factual evidence that is in the record. I will then apply those facts to any relevant provisions of the county's comprehensive plan and land use regulations. The standards and applicable criteria relevant to this hearing were identified in the public notice announcing the hearing. They are also set forth in the staff report. The public notice and the staff report are posted on the county's website, and they are also available directly from staff upon request. It is important that you direct all of your testimony to the standards and to the applicable criteria. If you believe a criterion applies that was not listed, you may address the unlisted criterion. However, I urge you to also explain why the criterion applies and to do so with specificity so that other participants may respond and so that I can address that issue in my decision. The failure to raise an issue with enough detail to enable me or the other participants to respond precludes your ability to appeal that issue to the Land Use Board of Appeals. Also, the failure to raise a constitutional or other issue relating to any proposed conditions of approval, again with enough detail that allows me to respond to the issue in my decision, precludes an action for damages in circuit court. As I just noted, I serve as the county's hearings officer in this matter, and in that role, my job is to be a neutral decision maker. Thus, while I have a contract with the county to serve in this role, I am obligated by the contract to remain impartial, and I do not represent the county's interests or the interests of any other participant. To that end, I'll state for the record that I do not have any relationship with the applicant, and I'm not aware of any connections I may have to other participants in this proceeding that would prevent me from remaining impartial. I have communicated briefly with staff, but only to discuss the particulars of today's hearing and not the substance of the application. I do not have any ex parte contacts to disclose. It is my obligation to preside over the hearing in an efficient manner. So before we begin, let me ask, does anyone wish to challenge my ability to hear this matter or to challenge the county's jurisdiction over the matter?
I see none in the audience or online.
All right, thank you. So before we move to the next part, then I would like to ask you, Ms. Mardell, do we have any participants online that look like they're going to be participating?
I believe we have one attendee RD. Do you believe that they'll be providing testimony? Are you aware? Okay. We have one person that may be providing testimony. I'm not sure. But just a reminder for that individual RD, if you would like to provide testimony, please use the raise hand button to notify us of that.
Okay, and then in the room, I assume we have the applicant. Are there others that will be participating?
Yes, we have at least one other individual participating. Are you also planning to? Behind you too? Yes. Okay. Yes, we just have the applicant and then one in-person commenter.
So it sounds pretty light. I just wanted to get a sense of volume. So, okay, with that, I'll turn it back over to you, Ms. Mardell, to deliver the staff report.
Excellent. Thank you very much. So my staff report today will be relatively brief. So just wanted to note the location of the subject property. It is made up of 7 different tax lots, primarily addressed off of O.B. Riley Road. Wanted to note that to the north is Strickler Avenue. O.B. Riley Road is to the east of the subject property, and this subject property is also to the north of the existing Cascades Academy campus. Surface mine numbers 370 is to the north. That's the Knife River Material Yard. That includes kind of a portion of the property as well. And there's approximately 22.5 acres for this subject property, of which 18.47 are EFU and 4.03 are zoned surface mine. The applicant, as noted previously, is seeking a plan designation change from agricultural and surface mining to rural residential exception area, and their zone change from exclusive farm use and surface mining to rural residential. I wanted to note that no Goal 3 exception is proposed by the applicant. Rather, the applicant is arguing that the subject property does not constitute agricultural land and therefore should be rezoned and redesignated for that purpose. We did receive 3 agency comments from our senior transportation planner confirming compliance with the transportation planning rule, our building official, noting a general comment regarding building review if this application were to move forward, and also a comment from Tumalo Town Ditch, which essentially just noted that a recent water rights transfer had been completed that was initiated by a previous property owner for a small amount of acre feet related to landscape irrigation. And they also noted that there is an easement on the property as well. I apologize, this hasn't been updated. We did receive one public comment prior to the start of today's hearing from Central Oregon Land Watch, and that has been uploaded to the record, and the applicant and the hearings officer have been made aware of that comment as well. With that, wanted to note that all record materials are published at the project webpage, which is bit.ly/Cascades Academy. And with that, I welcome any questions from the hearings officer.
Thank you. I think I have one question, and it might be able to also be answered by the applicant, but I was seeing some conflicting information about exactly which of the parcels have which zoning. And it seems like the actual surface mining zoning is the smaller portion and was tax lots 4,200, 4,300, and 4,400. But where I was seeing some conflicting information was on tax lot 302. Is there something in the record that I can look to that says exactly what, at least what the county's staff's position is on what the zoning for tax lot 302 is?
Sure. And just to clarify, was that 171206 302 64375 Obie Riley Road?
That's a good question. Let me see if I can. Yes, 171206.
Yeah, so I would say based on our county zoning map, which is our official zoning map on Dial, that's zoned EFU, Tumalo Redmond Bend subzone, but I can also ask the applicant to address that as well.
Okay, thank you. I'll probably ask the applicant that as well. That's all I have for staff though, thanks.
Great.
We
Thank
can
you.
have the applicant come up and give their presentation.
My PowerPoint that we can put up on, oh, there we go. Thank you. Good afternoon. My name is Tia Lewis. I'm an attorney for the applicant, and with me is Darren Hansen, who is a representative for Cascades Academy. I will be brief because our application materials are pretty complete, but Darren would also like to say a few words as a part of the applicant's presentation. So as Nicole indicated, the subject property is made up of 7 tax lots, 22 acres total, 4 acres zoned surface mining and 18 zoned EFU. And we do agree that tax lot 302 is zoned EFU. There was some in the past, a portion of the property that 17 of the 18 acres that is currently zoned EFU was zoned surface mining, and it still shows, I think, on the comprehensive plan as a surface mining designation, but we submitted into the record the ordinances under which that zone was changed. They're in the record as Exhibit 4. So again, it's the northern 4 acres that is zoned surface mining, and those 4 acres are a portion of surface mining site 370, which is the Knife River storage facility. And they have been separated from ownership from the mine operator since the 90s and been used for residential use since that time. The southern 18.5 acres was zoned, but 17 of that was zoned surface mining as site 304, and that was changed. Have that date somewhere here and in the, I think in the early 2000s. It is adjacent to the south of the Knife River storage. In fact, I'm going to switch this slide to the next. There we go. That gives you a little bit better view of what's going on. So the Knife River storage and processing site is to the north. It's adjacent to the Tumalo Irrigation District and the Tumalo Rural Community. Adjacent also to the Tumalo State Park and the Deschutes River to the east, as well as O.B. Riley Road. The only EFU area is adjacent to the west. There is a kind of a rectangular sliver. You can't see it as well on this map because we weren't able to blow it up as much, but that rectangular sliver to the west is the only EFU land in the area. Immediately adjacent is a 20-acre parcel owned by Rita Rice. She wrote into the record about her experience. She's owned that property since the 60s and lived on it with her husband, who has since passed away. But she submitted testimony into the record about her experience engaging in any sort of agricultural use of that property. And she does have some irrigated fields, but no significant agricultural use, primarily residential. Further to the west of her property of Miss Rice is a 46-acre property owned by Brandt Family Trust. It has several residences, including a medical hardship dwelling. It has evidence of irrigated land, although it doesn't appear to be growing crops or livestock. Again, we are adjacent to the Tumalo State Park to the east and the Deschutes River. So as indicated, the 17 acres of the 18 acres EFU was formerly zoned surface mining under Site 304, and it was rezoned in 2001. The decision for that rezoning is in the record as Exhibit 4. And it was indicated that it was rezoned by the applicant because the applicant had owned that property since the 90s, had a residential use on it and an irrigated pasture. There's been no farm activity since we've owned the property and no farm activity prior to that on the agriculturally zoned land in our application materials. The northern 4 acres of the surface mined zone property was a part of Site 370, and it was included, that site is included on the county's inventory as a storage site, not an extraction site. The EC is in the record as Exhibit 5. And these 4 acres have not been used as storage or mined as a part of the 370 operations. Again, they were transferred out of ownership of the mine operator in the 90s and have been in private ownership and residential use since that time. Knife River did write in support of our zone change. We have that in the record as Exhibit 9. And the adjacent EFU property owner wrote in, and it's in the record under the public comments. I'm going to skip this slide and come back to it. So these are the county rezoning standards under Deschutes County Code 18.136.020. I'm not going to go over these in great detail because the application materials are pretty complete, but under subsection A regarding the comprehensive plan, the evidence and argument in the record addressing this criterion is found at pages 6 through 16 of the burden of proof, as summarized in page 10 and pages 14 through 23 of the staff report. Specifically, the applicant has demonstrated consistency with the agricultural land policies at section 2.2, the water resource policies at section 2.5, the surface mining policies at section 2.10, and the rural growth policies found in chapter 3. Under subsection B, that the change is consistent with the purpose and intent of the proposed zone. This criterion is addressed in the application materials at pages 16 and 17, as summarized in the staff report at pages 10 and 11. We are seeking MUA 10 zoning, and the purpose is to preserve rural character while permitting development consistent with the area and the capacity of the resources. We've submitted, the existing school site has been operating compatibly in the area for approximately 13 years. And so there's no better evidence of the consistency with the use than the actual factual compatibility that's occurring, or that has been occurring for the past 13 years. With regard to subsection C, that changing the zoning will preserve the public health, safety, and welfare under subsection 1 regarding public facilities and services. The evidence in the record is in the burden of proof, page 17. We submitted the traffic study as Exhibit 11 and the Exhibits 8 and 10 demonstrating rural fire protection services, as well as the future development application processes through the county ensure that the adequacy of public facilities and services will be available at the time the development application is submitted. With regard to subsection 2, the impacts on the surrounding use will be consistent with the goals and policies of the comp plan. We've submitted extensive evidence in the burden of proof addressing all the comp plan policies, and again in pages 6 through 16 of the burden of proof. And then lastly, with regard to a change in circumstances and mistake, the property was zoned under the county zoning ordinance in 1979. The agricultural zoning in 79 was based on very generalized soil data, and we now have the benefit in this case of a site-specific soils analysis in the record as Exhibit 7, establishing that the soils are not agricultural soils. And with regard to a change in circumstances, there's not really much that hasn't changed around this property since 1979. Again, we have the updated soils data, but we also have the lack of use for the mining, the decline in farm operations, the establishment of the school and the Tumalo rural community, as well as the Knife River storage and processing facility, the Tumalo State Park, and the surrounding development. So with regard to the non-resource rezoning process, it's also very heavily regulated by state law. Those provisions are found in the Oregon revised statutes, the Oregon administrative rules, and the statewide planning goals, specifically goals 3 and 5 as it relates to this piece of property. Up until Landwatch filed a opposition letter a couple of hours ago, we didn't believe there was any debate about the goal 5, about the changing of the surface mining zone, which is a transitional zone. And when it's no longer being used for surface mining purposes, it should be changed to a different zone. We didn't believe there was any real dispute about changing that, and that the reclamation was complete. However, we will talk about some post-hearing briefing to address some of the issues that Landwatch has raised in their letter. But this decision is very similar to the decision this hearings officer made on the Caldera zone change for the Miller Pit in terms of the Goal 5 analysis. So for purposes of this presentation, we're going to focus on the Goal 3 analysis regarding the non-resource designation. For agricultural land as used in Goal 3, it is defined as land classified predominantly as Class 1 through 6 soils in Central Oregon. The non-resource process to change zoning rather than a goal exception process is focused on demonstrating that the land does not meet the definition for the resource designation and therefore does not warrant protection of the goals. This process, as initially approved by DLCD in Klamath County in 1988 and as reaffirmed in Wetherall v. Douglas County in 2006, and the line of cases that have followed it since that time. The present site is Class 7 and 8 soils, 68% as demonstrated by the soil study submitted as Exhibit 7, and it has no forest soils. In addition to the definition with regard to the non-resource designation, there are also a number of other factors that must be considered. What we call the suitability factors, which are outlined at OAR 660-033-00201AB. Considering such characteristics such as soil fertility, suitability for grazing, climatic conditions, and the like. Those suitability factors were addressed by our soil scientist in Exhibit 7, and they are summarized at the burden of proof at pages 24 through 29, and the staff report at pages 28 through 32. In addition to the suitability factors, there's what we call the locational rule, again at OAR 660-033-00201AC. And that was recently analyzed in the 710 case, also called the Eden case, which requires an analysis of the subject property in the context of adjacent and nearby agricultural lands. I do want to clarify in the staff report, staff indicated that the applicant's position was that the locational rule or the locational analysis was not relevant. And to the extent I said that, that was not what I meant. What I meant is that the subject property does not have adjacent or nearby lands in agricultural use. And so the analysis in this case is far different than what was undertaken in the 710 and the Eden case with regard to that locational rule. And then lastly, with regard to the non-resource process, the other factor which must be considered is the farm unit rule. That is at OAR 660.033.00201B. And in the present case, the subject property is not a part of a farm unit. A farm unit is defined in the ORS as land in common ownership, and we do not have any land in common ownership with the subject property that has been a part of agricultural use. So I'm going to go back to that other side that we skipped. So basically, the subject property, the key facts are that the soils report confirms that it does not contain a significant aggregate resource and that the surface mining zoning should be removed. And it also confirms that it's not agricultural soils and that it's primarily Class 7 and 8 soils. The transportation analysis submitted as Exhibit 11 confirms that the proposal complies with the transportation planning rule. And the evidence in the record demonstrates that the application is in the public interest by rezoning excess surface mining land and unproductive agricultural land to a use that is proven to be consistent and compatible with the uses in the MUA 10 zone and the surrounding area. We would like to reserve an opportunity for a rebuttal, and we'd be happy to answer any questions that the hearings officer has now. In addition, Darren would like to say a few words before the applicant's presentation is complete. Thank you.
Okay, thank you. You can go ahead, complete it.
Thank you. Good afternoon. My name is Darren Hansen. I'm the Director of Business and Operations at Cascades Academy, and we reside at 19860 Tumalo Reservoir Road in Bend, Oregon here. This is the 22nd year that Cascades has been serving the Central Oregon community as an independent educational institution. Our first 10 years were spent in the previous DMV building off Studio Road behind the post office here in Bend, where many local independent schools got their start and still exist today. Through the generosity of our families and the community, we were able to acquire our current 13-acre campus outside of Tumalo, adjacent to Tumalo State Park, as Tia mentioned. As an educational institution where our mission and curriculum is experientially focused in the classroom and what are considered traditional academic subjects, through our engaging electives, and in our robust off-campus outdoor and traveling school programs. Our kids are out experience our campus, our land, and the Deschutes River daily. They're engaged with partners weekly throughout the region in learning and service, and traveling regionally and internationally to instill a global sense of connection. Environmental sustainability is at the core of our value set, and through the development of the current campus and our daily activities, we take that responsibility willingly and seriously. Year after year, we are recognized as one of the top 10 nonprofits and top 10 green places to work in Oregon. For the past 13 years in Tumalo, we've been excellent neighbors, connected to our community, and stewarded the land we are blessed with naturally and wisely. The school's been fortunate to be able to acquire the land adjacent to the campus as it's become available so we could grow our footprint to almost 45 acres. And again, through the generosity of our families and community. Our current campus and facilities were value engineered and sustainably focused at inception, with an intent to minimize impact to the land and facilitate continued migration of wildlife through the Deschutes Basin. As we begin the planning process around how the school can evolve and fold the new lands into our campus in a meaningful way, we are committed to continuing stewardship of the land responsibly and to maintain the natural character in concert with our surrounding neighbors and community. We chose this plan amendment path as it was the best suited to align with the mixed zoning of this 23 acres to the true character of the land, to be consistent with the school's adjacent 20 acres zoned MUA 10, and provide clarity around potential development while ultimately conserving our finite resources. Historical records of the property and its past uses as shared by the previous owner and neighbor, as well as soils analysis, supports our reasoning. If we truly believe the acreage in question was coveted productive farmland, and there was documented reasoning around how 18 of the 23 acres was transformed from surface mining to EFU in the 2000s, which the county staff report highlights isn't clear nor understood, then we'd probably be going a different path because it's just not our way. As an institution, we've proven we are excellent stewards of the land we are entrusted with. We are committed to continuing to maximize its natural character and how it fits into its surroundings. And as such, we hope the county will decide favorably, which will enable us to continue to serve our community to the utmost abilities. Thank you for the opportunity to share this today.
That concludes the applicant's presentation. We'd be happy to answer any questions, or we can come back up on rebuttal.
Yeah, I think I have two questions initially, just sort of more of kind of legal stuff. On the requirements for rezoning the surface mining zone and the language that speaks to that once a site that has been fully or partially mined and no longer has a resource, it occurs to me this is kind of a different situation because the particular sites were never intended to be mined. So I'm curious how you would encourage me to interpret that language that just doesn't seem to, if you take just the plain language, it doesn't, it's a square peg in a round hole kind of situation. And I'm just wondering if it means that being mined has a different meaning, or if there's some other intent behind it. Just something you can point me to that would explain the interpretation of this code in this situation.
Thank you. Yeah, I struggled with that as well as I was preparing the application materials. It's very clear that this site was not zoned surface mining for extraction. It was zoned surface mining for storage and processing. And so in my opinion, not all criteria apply to every application. You have to look at the criteria and determine whether or not the facts of the application, whether the application contains facts that would allow you to apply that criterion. And in this particular case, there was no mining and extraction occurring on the subject property. So I think that the intent of the criterion is to determine, is the property useful for a part of the mine? Is there still a resource there, or is it being used as a part of the mine? And in this case, it was not used, it was never used as a part of the mine. And the mining operator is very forthright about that. So I think that to the extent that that criterion, the intent behind it, was intended to analyze whether or not the subject property is needed and useful and important to the Goal 5 resource. And in this case, we've demonstrated that it is not.
Thank you. The second question, and I understand trying to address all the criteria, but on the criterion that there's been a change in circumstances or a mistake was made in zoning the property in question, you've kind of addressed both. The one that jumps out to me is whether a mistake was actually made. And I wonder if you could give a little bit more detail on that. The application materials seem to say that the zoning was done based on the soil data that existed at the time. And so I just wonder if you can put more detail on what the actual mistake was, or the alleged mistake.
I mean, if you're talking about the EFU land, I think that the mistake is that it actually contains agricultural soils. The county's data when they zoned things agricultural in 79 was very limited. And we now have the benefit of much more specific data. So I think that if the county were looking today at this property and whether or not the soils are agricultural, the decision would be different. With regard to the surface mining, I think that there was a mistake in the sense that they zoned more property for the storage and processing site than was needed by the operator. And the evidence is based on the historical use.
Okay, thank you.
Thank you.
Those are the only questions I have for the applicant, and you, of course, can come back for rebuttal after the rest of the testimony.
Thank you.
And Ms. Martell, can you call up the first, maybe only person that signed up to testify?
Rory Isbell.
Good afternoon, Hearings Officer Brooks. For the record, my name is Rory Isbell. I'm a staff attorney with Central Oregon Land Watch. Our address is 2843 Northwest Lolo Drive, Suite 200, Bend, Oregon 97703. Before my clock starts ticking, I did just hand to staff and the applicant a copy of our written comments. They are somewhat lengthy, and before I begin, I want to see if you would grant leave for me to go beyond the normal 3 minutes for oral testimony.
Yeah, I think in light of the relatively few participants, if you need a little bit more time, that's fine. I say that on the assumption that you will be addressing criteria only and not droning on, but I'll let you know if I feel like you go too far.
Thank you very much. And yes, I will abide by that recommendation and stick to the criteria. Landwatch is opposed to this application. I want to clarify before I really jump in. We have no position on what we understand as the planned use by this applicant to expand their school site. We are, however, opposed to redesignating and rezoning the subject property, 18 acres of which is agricultural land zoned EFU, to a rural residential zone. Kind of flowing from that, one of the headings in my written comments today explains that a school use is an allowed use in the EFU zone. It's a conditionally permitted use, and there's examples across the state of schools being cited in Oregon in the EFU zone. We also just heard testimony from the applicant that their current school use on the adjacent property to the south has existed, peacefully or without conflict in this area. I do acknowledge that that property does have different zoning, but I think it speaks to the fact that schools can be cited on EFU properties in Oregon with the conditional use criteria that apply to minimize some of those conflicts. The county code requires that following use as a mining resource, properties in the surface mining zone shall be rezoned to the subsequent use zone identified in the comprehensive plan. The majority of this property, 18 acres that's currently zoned EFU, is planned for agricultural use by the comprehensive plan. We just heard that back in 2001, that portion of the property, its zoning was changed to agriculture and EFU. So we believe it would violate the county code at DCC 1852-200, which requires, it uses the word shall, that properties be zoned to the subsequent use in the comprehensive plan. The county's already made that decision, and the subsequent use is agriculture. You just asked a question about this, but the county's criteria for rezoning, one of those criteria requires a demonstration that no change in conditions or mistake has been made. Similar point here, back in 2001, so just over 20 years ago, 18 acres of this property was designated for agriculture and zoned EFU. There hasn't been a mistake. There was no mistake in that decision. That was a final land use decision of the county. It wasn't appealed. There was no mistake, and there has been no change in circumstances in those 23 years since that decision was made. The next point, and if you're following along, I'm on page 4 of the written comments, just flipping through them here. But 3 different sources describe the reclamation obligations on this surface mining property, or formerly surface mining property, for the 18 acres currently zoned EFU. Those come in the form of a county site plan decision, SP 9359, a Dogami reclamation plan for Dogami mining site 09-0006, and in a development agreement executed by the former owner of the property with the county in conjunction with that 1993 site plan decision. All 3 of those sources detail the reclamation requirements on the former mining site. And just to clarify, I'm speaking to the currently EFU zoned portion of the property, which is a different mining site than those 3 smaller storage mining properties on the northern part. So these 3 sources with the reclamation that they require, they describe that at least 18 inches of a cover layer of soil must be laid over the top of the former mining site, and that the site will be replanted with Siberian wheatgrass, nomad alfalfa, and crested wheat, and returned to its current use, this is in 1993, as an irrigated pasture. Based on information that the applicant has submitted in support of this application, primarily the soil study they've referenced, it appears that those reclamation requirements, which are conditions of approval from a 1993 Deschutes County land use decision, have not been met. So it's our position that this property is in violation of those conditions of approval from 1993. If indeed, as the soil study states, significant portions of the property that were formerly mined do not have those 18 inches of topsoil replaced. I want to quickly touch on Goal 12 and the transportation planning rule. It looks like the trip study that is provided with the application does not estimate the number of trips that would accompany what we understand to be the intended use of this property, which is a school expansion. So it's not clear to us that the transportation planning rule has been satisfied, because it might have inaccurately estimated the number of trips that would result from this rezoning. Back to the soils piece, and really starting to dig in on the Goal 3 issues here. State law does provide for additional soils information to be submitted to support some types of applications, land use applications on EFU land. For properties with high value soil, state law does not permit a county to change the soil classifications to anything other than what the NRCS soil classifications are for that property. So this is Oregon Administrative Rule 660-033-00308. And Deschutes County, in its code, classifies the soils of the subject property as high value soils. Almost all. There's a small percentage on the west side, it's maybe a quarter acre that's a different soil class, but the entirety of the rest of the property is classified by Deschutes County as high value soils. So we don't believe for this plan amendment zone change application that any soils information other than what the NRCS reports can be used to make determinations about whether this is agricultural land and protected by Goal 3. The soil study that I referenced, this relates to the reclamation obligations for this property. So it identifies 8 acres of this property as what it describes as complete topsoil and subsoil removal. And it classifies those 8 acres as class 7 and 8 soils based on the fact that it's a former mining site and the soils have been removed. Well, as I've just described, the reclamation obligations for this property are to replace the soils with the high value soils that existed before the mining of this property with at least 18 inches and to return them to agricultural use. And, I want to note, because sometimes agricultural use of a previous mining site, its feasibility is questioned. I've included in our exhibits some documents from DOGAMI, the Oregon Department of Geology and Mineral Industries, that explains how it's very common to reclaim former surface mining properties for agricultural use. In fact, of all the post-mining uses that mining sites have been reclaimed to in Oregon, DOGAMI said, and this is information is a little old. This is from a presentation DOGAMI gave to the legislature in 2015. But as of that time, the #1 post-mining land use category was agriculture. And I've also included this best practices guide for reclamation that describes how properties can be reclaimed for agriculture upon exhaustion of a mineral resource. So we don't believe the soils report is accurate in its characterization of the soils when the soils have not been reclaimed as required by those 3 sources I identified earlier. So there's a few classes that the soil study identifies as not agricultural, one of which I just said, this topsoil removal. Another is half an acre of ditch or berm. If a ditch was dug and a berm was, cast along the side of that ditch, we see it as fairly simple, maybe a day with a backhoe to put that soil back in the ditch, and it's no longer Class 8 soils as this soil study claims it might be. We walked through the OARs for the definition of agricultural lands. It's OAR 660-033-0020-1A. I won't go through the details here, but we do believe that those 7 factors indicate the subject property is suitable for farm use. We also include some historical aerial imagery of the subject property that really just verifies what we see in those previous county land use decisions, that the use prior to the mining use of the property was as an irrigated pasture, which is a farm use, of course. There's case law that I cite in our written comments that says that past use of a property is not perhaps determinative, but is a strong indication about whether property is agricultural land protected by Goal 3. I will touch on Goal 5. I know the applicant mentioned our Goal 5 comments in their testimony. Our Goal 5 comments aren't necessarily about the surface mining and the mineral resource on the subject property, but really about the county's scenic views resource, which is a Goal 5 resource. The county inventoried in the early 90s several locations and corridors throughout the county that it identified as valuable for their scenic views and landscapes. And on this property, 2 of those resources are present. One of which is the landscape management zone along the Deschutes River. So that's a Goal 5 resource that protects scenic views in a 660-foot corridor from the center line of the Deschutes River. A portion of the subject property, not all of it, intersects with that scenic views Goal 5 resource. And the entirety of the subject property intersects with another inventoried Goal 5 resource in Deschutes County, which is the State Scenic Waterway Corridor. So that Scenic Waterway Corridor is separately inventoried as a Goal 5 resource by Deschutes County. There's a third Goal 5 resource that we realize exists on the subject property, and that is wetlands identified in the U.S. Fish and Wildlife Service National Wetland Inventory. And again, in Deschutes County's Goal 5 program, it identifies any wetland identified in that U.S. Fish and Wildlife Inventory as a significant Goal 5 resource in the county. So when a land use application would propose a potentially new conflicting use on a Goal 5 resource, the county has to walk through that Goal 5 process in its Chapter 23 of OAR Division 660. Which is, of course, inventorying, determining significance, conducting an EC analysis, and developing a program to achieve the goal for that resource. It doesn't appear in the current application that Goal 5 process has been completed for these 3 Goal 5 resources that appears exist on the subject property. I also touch on Goal 14. I am at the end of our comments now. This application, it is for a rural residential zone. It would allow an increase in density of allowed residences on the site. We outlined the factors that the Oregon Supreme Court had identified in its Curry County decision from back in 1986, as interpreted in subsequent decisions by LUBA. Those are density, proximity to an urban growth boundary, and whether it would frustrate the purpose of an urban growth boundary, and whether the types and levels of services for a property would be urban in nature. We do believe there's a strong argument that all 3 of those would be met here, and that the application would require an exception to Goal 14. That concludes our comments on this application. Thank you once again for the extra time. I know that was more than 3 minutes. Be happy to answer any questions you might have for me.
I think I have one question. I may have another one. With respect to the ability to rezone the property from the surface mining overlay, you were, I've got your comments here, so I might butcher them. So tell me if I've got your position wrong, but um, tell me how that applies differently, or it actually sounds like you don't think it applies differently for the parcels that are currently zoned with the SM zone and the ones that are in the EFU. The ones that are in the EFU were already rezoned, or at least most of it was already rezoned from the surface minded EFU. Are you saying that because of the way the code reads, you could never rezone it later? So the county went through the process of removing the SM zone, going to the EFU. Are you saying that that's locked in and that those sites can never again be rezoned?
I think because of the language of the county code that you're citing, yes, I believe that's how that language has to be interpreted. It says that the property shall be rezoned to the use identified in the comprehensive plan. So I think in short, yes, that's our position on those 18 acres that that were rezoned to EFU in 2001.
Right. Thank you. Let me just check my notes. This may be, I did not get through all your comments. I got them this afternoon and tried to go through them. So it may already be in here, but on your goal 14 argument, are you, I guess you're referring to the MUA zone as a residential zone, and that it's, for all intents and purposes, I guess an urban zone. Can you just tell me more about how your position on that this particular zone is creating urban density, urban levels of service?
Sure. So it's our position that as interpreted by the Supreme Court in the Curry County case from 1986, every PAPA, so post-acknowledgement plan amendment, is different as far as its goal 14 compliance. And that's because the factors that the Supreme Court laid out, they aren't uniform for a zone that might, a zone of general applicability that might exist in an entire county. They are site specific. So they require an analysis of things like proximity to a UGB. Obviously, depending on where a property is located in a county, its proximity to an urban growth boundary will vary. So we don't believe that the mere fact that the county has this MUA 10 zone guarantees that every post-acknowledgement plan amendment that seeks that MUA 10 zone is compliant with goal 14. And that's because it's a site-specific, property-specific inquiry. And as far as I think what I heard the second half of your question about, those factors and how they're applied to this property, it's a little over a mile from the Bend urban growth boundary. The zoning, it has its minimum lot size, but it would increase the number of dwellings allowed on this property by 3, go from 1 to 3. And because of that proximity to an urban growth boundary, I think there's a high likelihood that residents that could live on this property, if it's rezoned to a residential use, would rely on urban services from the city of Bend being only a mile away. So we think there's a strong argument. Again, every property is different. We believe there's a strong argument that this would urbanize rural land in violation of goal 14.
And then last kind of touch on that. So I think for this particular application, there's kind of an anticipated use, but there's not a proposed development in this. So what is your suggestion to me for how I analyze the MUA 10 zone in this particular situation when there's not a particular development being proposed with respect to whether or not urban services are required or likely?
Yeah, that's an interesting question. And I don't believe there is one answer to that question. I'm not aware, at least, of a source of law that would guide an answer to that question, because the zone that's being sought, of course, allows many uses. But we also, have heard in the applicant's narrative what their intended uses of this property. So, I think we could take the applicant at their word, but we also have to foresee the potential that land changes hands. No one can predict the future. Once this is rezoned, any of those uses allowed in the zone could feasibly be developed by this applicant or a subsequent owner of the property. So I guess as I think through that as I'm talking, I think both need to be analyzed, because the MUA 10 zone allows the uses that it allows. And, we make this somewhat related argument in the goal 12 comments that I provided, that here we have an identified use, but I don't see in the transportation memo, one of the applicant's exhibit, estimating the trips that would apply to that use that is described of school expansion.
And is your goal 12 issues are in the written comments you submitted?
Yes, they are.
Okay, I might have glanced over that. Okay, I think that's all the questions I have for you. I appreciate it.
Thank you.
And then, Ms. Mardell, I assume no one else has signed up to testify.
That is correct. I just wanted to give one more opportunity just in case for those who are attending remotely. If you'd like to provide testimony, please select the raise hand feature. Okay. Yep, looks like we have no other parties wishing to testify.
Okay, so if the applicant would like to come up for rebuttal.
Thank you again, Tia Lewis, for the record. I'll be brief because I would like to submit some rebuttal in writing and hold the record open so we can talk about that at the end of this. Yeah, so I'm just going to touch just briefly on a couple of the issues. And again, we'll do more extensive in writing. With regard to the surface mining arguments, the prior reclamation obligations, I think the hearings officer correctly realizes that the land that was formerly zoned surface mining that is currently zoned EFU, the criteria related to changing the zoning from EFU to the MUA 10 zone are not surface mining criteria. They are the criteria that we addressed regarding the county's rezoning standards and the state law. The idea that the prior reclamation requirements were not complete at the time that the rezone decision was initiated or final is a collateral attack on that prior rezoning decision. That decision was a final decision, and the question is whether or not the application meets the criteria to rezone it from EFU to MUA 10, not whether the prior reclamation obligations were complete. With regard to the transportation planning rule, the TPR or the goal 12 issues, the TPR requires the applicant to study the worst case scenario for the transportation impacts, which is what the applicant did. And the county's transportation planner confirmed that the application materials comply with the TPR. With regard to the LM zone, the current campus is zoned MUA 10 and is in the LM zone. And the MUA 10 zone is an acknowledged zone in the county, and the county has acknowledged that its uses are consistent with the Goal 5 resources and the LM zone, not conflicting. The same is true for Goal 14. However, we're not opposed to conducting the Curry analysis for Goal 14 with regard to this property. I think it's important to note that the prior irrigated pasture doesn't equate to a farm use. Farm use is defined, and it's defined in terms of the primary purpose of a farm use is to obtain a profit in money. And that includes a consideration of the cost to engage in the farm use. And this information is relevant to determine whether or not there's agricultural land. And so lastly, I think it's really important to note that Land Watch isn't opposed to our use, but they're opposed to rezoning this property to allow that use to occur in the most economical and efficient fashion, which elevates form over substance in this circumstance. And it expects landowners to use scarce resources irresponsibly. The suggestion that we should take scarce water resources and 2 feet of topsoil and apply it to this land and somehow grow something here between Knife River's storage facility and the school along the Deschutes River and the Tumalo State Park is ridiculous. And no reasonable farmer or landowner would engage in that process. And so there's got to be some connection with reality here instead of just all the law. That's what the property owner is doing here, and the property owners compatibly existed in this site for 13 years. So we're hoping that the county will see fit to rezone the property accordingly. Thank you.
Thank you. I don't have any further questions for you. Before we talk about schedule, then I'll see if staff has any final comments they want to make, and we'll go from there.
Thank you.
Yeah, thank you, Hearings Officer Brooks. No further comments from staff. I do have a couple suggestions for open record period dates, but look to the hearings officer if you'd like to jump into that.
So, Ms. Lewis, why don't you tell me what you were thinking in terms of keeping the record open? I think there's a lot of flexibility here because it's a plan amendment on time frame. I will also just be really candid up front that the last half of December is really unavailable for me. So my ability to turn around a decision is going to be impacted by however long we keep the record open, but I'm open to whatever suggestions you have and we can work through it.
Thank you. Yeah, it's tough for me too. So I think we're going to push it past your past your date. I would like to have until December 4th to respond to the information that was submitted tonight. And so I don't know, usually, or today, excuse me, usually the open record periods, the first period is open to anybody, and then the rebuttal period is only to rebut the information that comes in the first period. And I need to be able to rebut the information that came in today.
Sure.
So I don't want to do the 7, 7, and 7 because that just won't work very well. So I would love for the first period to end. Excuse me, I just lost my calendar. There we go. If the first period could end on the 4th, I think, which is a Thursday, or no, excuse me, the 5th. And then we could do the usual after that. So then another 7 and 7, 12 and 19.
Sorry, I'm just looking. Would you have any well, I think that works for me. I guess since there's only one other participant, I feel compelled to give Mr. Isbell a chance to weigh in on that with the kind of a 21-7-7 approach.
Yeah, well, and to the extent that that impacts your contractual deadline to issue the decision, we would be willing to agree that to go to whatever works for your schedule once it's closed. We're not gonna hold your feet to the fire over the holidays.
Mr. Isbell, do you have concerns with that schedule?
I think I do. The 3 weeks as the initial period and then just 1 week for rebuttal seems a little lopsided. So I understand and don't object to the request for additional time, but I would hope to see those 2 periods a little more even, maybe 2 weeks and 2 weeks.
Yeah, I need the 3, but I would be happy to do 2 for rebuttal if that would be okay. I can't do 2 on the first period because it lands on Thanksgiving.
Sure.
Yeah.
2 weeks for that second rebuttal period would be a fair compromise to me.
Okay. So that sounds good. And then I don't think this affects Central Oregon Land Watch, but if we did that 1, 2, 3, the final legal argument we're going to do on the 26th. I'm not even going to be in the country then and won't be able to see it. So if we could just have the final legal argument come in right after the new year, the record will have already been closed at that point. I'd prefer to do that. And then that way we don't have a due date on the 26th either, which is, I never thought a fair due date for anyone. So that would be more like a 3-2-2 process, 3 weeks, 2 weeks, 2 weeks. Does anyone object to that?
No.
No
So
objection.
would that put final argument due on January 2nd, though?
It would, but you also have a lot more time to do it instead of the 7 days.
It's fine.
Okay, all right. So that would be, and I think the staff will go over particular dates again, but just feeding into that. So an open record period through December 5th, a rebuttal period through December 19th, and then a final legal argument period through January 2nd. If that works, then we'll have, oh, look, see, staff's already plugged that in. That's nice and quick. Before we get to those final details, then, is there anything else that needs to come in front of the hearings officer, or can I turn this over to staff to do the final details? We're good? All right, Ms. Marnell.
All right, excellent. So for the open record period, please keep in mind all submittals should be addressed to me, Nicole Mardell, senior planner, and they should, for email submittals, you should use my email shown here, nicole.mardell@deschutes.org. As a note, the county does not retrieve information from a website link or personal cloud storage device. It is your responsibility to submit all evidence and testimony you want the hearings officer to consider. Any electronic submittals must be received by the county server by 4 p.m. So please do not wait until the last minute to submit your evidence and testimony. And also please note that there are some, file size limitations for the county server as well. So please coordinate with me if you have any large file sizes. With that, I believe that concludes all of our open record period information.
Okay, thank you. And with that, it's 2:06 and we will go off the record. Thank you.
Great, thank you.